First of all, I just want to say thank you for coming and welcome to the Cleveland Municipal Court. This is truly an auspicious moment in our history as we start in a direction that we think is going to be ultimately beneficial not only to those who happen to get caught up in the criminal justice system and find themselves behind bars, but to the community at large. We think that we have discovered a methodology that will allow us to be much more precise in our determinations as to the people who need to be behind bars and those who need to be released even though they have been charged with an offense. I'd like to start off this morning really by letting those who you see arrayed behind me to introduce themselves to you so that you can see the vast array of support that what we're going to talk about here today has garnered in the community. And so I'm just going to start with Director McGrath.
Mike McGrath, Director of Public Safety from the City of Cleveland.
Robert Triazzi, Cuyahoga County Law Director.
Lane Griffin, Executive Director, Community Relations Board, City of Cleveland.
Lisa Williamson, representing Prosecutor-elect Mike O'Malley.
Tim McGinney, County Prosecutor.
Kevin Kelly, President, Cleveland City Council.
Frank Jackson, Mayor, Cleveland.
Matt Alsdorf, Vice President of Criminal Justice at the Laura and John Arnold Foundation.
Bob Tobin, Cuyahoga County Public Defender.
Joe Zone, Judge, Cleveland Municipal Court.
Earl Turner, Clerk of Cleveland Municipal Court.
Charles Patton, Judge, Cleveland Municipal Court.
Armin Budish, County Executive.
Judge John Russo, Presiding Administrative Judge, Cuyahoga County.
Kimberly Barnett Mills, City of Cleveland, Chief Prosecutor.
Lisa Spaghetti, Jail Manager, Division of Corrections.
KJ Montgomery, Judge of Shaker Heights Court and representative of the Northern Ohio Municipal Judges Association.
George Taylor, Chief Deputy, Cuyahoga County Sheriff's Department.
Frank Bowman, Chief Community Safety Officer for Cuyahoga County.
And Becky Rupert Mazan, Executive Director of the Cleveland Metropolitan Bar Association.
Thank you. This event isn't something that just all of a sudden happened. It wasn't as though those of us on the bench here in Cleveland woke up one morning and said, I have an idea, let's do bail reform. This has actually been something that's been in the works here in Cleveland for some period of time, beginning actually around 2009 when Judge Emanuela Groves brought to the attention of the bench that there was a problem with individuals who were being arrested for capiases involving minor misdemeanor offenses and were being jailed and held in jail sometimes for 2, 3, 4, or 5 days before they saw a judge. This is particularly troublesome given the fact that minor misdemeanors under Ohio law are not jailable offenses. But when somebody missed a court date, we were issuing capiases for them. Some judges, or sometimes probably most of us, were putting a little money on those bonds in order to make sure that those people ultimately came to court. We took a look at that and determined that we were actually violating the Constitution by continuing to do that. And so we made a change, and our change resulted in people who were arrested on those capiases coming into the detention facility, making a decision as to whether or not they wanted to have their case heard in court, whether they wanted to enter a plea of no contest or guilty, and being able to bond right out as soon as they made that determination known to the folks at the detention facility. A couple of years later, in 2011, we took another step. We were looking at the fact that we had people who were charged with felonies and other significant misdemeanor offenses that were being held in jail for a prolonged period of time as they awaited their opportunity to see a judge. We found that there was case law from the U.S. Supreme Court in the case of County of Riverside versus McLaughlin that indicated that no one should be held incarceration for more than 48 hours without having seen a judicial officer who made a determination as to whether or not their detention should continue or whether they should be released because there wasn't enough evidence to hold them. In conjunction with the City of Cleveland and all of the judges of the Cleveland Municipal Court, we worked through and came up with a process whereby we could make sure that people were seen, generally speaking, within 24 hours, but sometimes within 36, and ultimately no one was held more than 48 hours under the schema. That effort caught the attention of the former county prosecutor, Bill Mason, who talked to the folks in the suburban jurisdictions about what we were doing in Cleveland. And between Cleveland and the county prosecutor and the suburban jurisdictions, they also adopted processes that looked at 48 hours as being the maximum period of time that an individual should be held. Do people get held longer than that? Well, sometimes they do. And there are occasions when, despite our best efforts, we're not making those decisions in a timely fashion, even though we're doing it now in probably 90+% of the cases. Earlier or actually late last year, I had the good fortune to be invited to attend a convening at the White House that was offered up by the Justice Department to take a look at situations involving fines, fees, and bail. The convening included a 7-hour symposium at the White House where we were treated to an array of professionals who have been looking at these issues over a period of time. And one of the things that they pointed out was that in too many jurisdictions across the country, people were being held in jail, not because they were dangerous, not because it was unlikely that they were going to return when they should to have their case heard, but simply because of the fact that they didn't have the money to post for a monetary bond. And they pointed out that in many instances this was done because of bail schedules that jurisdictions had. I have to tell you that attending those meetings constituted for me a transformative moment. So I came back to Cleveland and I talked to the judges of the Cleveland Municipal Court and I shared with them what I discovered, and I indicated that we had a bail bond schedule that required monetary bonds for certain classes of cases, and that the monetary amount that we had put up had no nexus to whether or not those people were dangerous or whether or not they were likely to return to court, and that we should do something to take a look at how we could change that. The judges unanimously decided to modify the bail schedule so that individuals who were charged with nonviolent misdemeanors, who had no other outstanding wants or warrants, would be allowed to secure their liberty on their promise to return to court. And that's been in place since January, actually the first part of February of this year. So, subsequent to that time, I happened to be appointed to serve on the board of directors for the National Center for State Courts, and they established a national task force on fines, fees, and bail. And our own Chief Justice, Maureen O'Connor, was appointed to be the chair of that effort. And fortunately, I got an opportunity to actually serve on that task force. During the course of the early part of this year, I became aware of the fact that County Prosecutor Tim McGinty had been in touch with one of the organizations that had presented at the symposium, the Arnold Foundation, and that the county prosecutor's office here in Cleveland, Cuyahoga County, was looking at the possibility of partnering with the Arnold Foundation for if not first ever, one of the rare occasions when they were actually going to partner with a prosecutor's office. They made a presentation here in Cleveland. I attended that presentation, and during that presentation, I was, for lack of a better term, jazzed by what I heard. Matt Alsdorf, who you'll hear from next, made a presentation as to exactly what the Arnold Foundation was doing, not just with prosecutors, but with courts. And at the conclusion of his presentation, I went up and I told him, I said, you know, I know that you're working with the county prosecutor, but the city of Cleveland, the Cleveland Municipal Court wants in. And from that time forward, we have had an ongoing conversation about the prospects of our court using the public safety assessment tool, which uses evidence and science to make determinations as it relates to who is most likely to return to court and who is most likely to commit an additional offense while they are out on bond, so that our decisions can be based on something other than our best guess. Those conversations have resulted in what you see here today, as we've talked to folks all over the county about the possibility and the prospect of having the Arnold Foundation and the Cleveland Municipal Court actually partner to bring the PSA here. We are participating and working with Judge Russo of the Common Pleas Court in his effort to take a look at how these issues play out in the felony court. And what we are hopeful to do is to have what we do here in Cleveland provide a basis for the folks in the county Common Pleas Court to have good information coming from us to them to assist them in the decisions that they are charged with making, and to put us in a position where we can kind of conjoin our effort and we can show proof of concept on this effort. So we are very pleased today to invite the Arnold Foundation to come and present to our community exactly what the nature of our agreement is, and to give some overview as to what we can expect. And to that end, I want to introduce Matt Alsdorf of the Laura and John Arnold Foundation and have him say a few words.
Thank you very much, Judge. I have to say I've given a lot of presentations and no one has ever been jazzed after them. So hopefully this is the start of a trend. So good morning, everyone. Thank you, Judge Adrien, for that introduction and for your leadership on criminal justice reform in Cuyahoga County and the city of Cleveland. I also wanted to thank Mayor Frank Jackson, County Executive Armand Budish, Prosecutor Tim McGinty, and Public Defender Robert Tobick for being here today, and also for their leadership on these crucial issues. It's been a pleasure to work with Judge Adrien here and the other criminal justice leaders here in Cleveland over the past few months. And in that time, what has become clear to us at the Foundation, and what you can see around here, is the extraordinary degree of momentum and support that these crucial criminal justice reforms have in this community. And in particular, the pretrial criminal justice reforms that we're discussing here today in connection with the adoption of the public safety assessment. At the Arnold Foundation, we really believe that pretrial reform can have long-lasting and significant impacts on the entire criminal justice system. And the reason that is that the decisions that are made at this stage of the process, the first decisions made in a potentially criminal case, have long-term impacts throughout that case and have significant impacts for public safety, for fairness, and for the efficient use of the limited public resources that we have. Judges are responsible for making these really important decisions every day about whether to release someone or detain them or release them with certain conditions. But as we looked across the country, what we found is that very few judges, very few courts have access to very much information about the defendants and the risks they might or might not pose. And I think, we can all probably agree that there are certain defendants who may need to be detained in jail while awaiting trial. But we also know that in many cities, there are a lot of low-risk, nonviolent defendants who are needlessly detained. This has negative consequences, certainly for the individual, but also for our community. And there's a really intuitive reason for that, which is that even just a few days behind bars can cause somebody to lose their job, lose their housing, lose their custody of their children. It can have massive impacts on their lives, and can in fact sort of perpetuate the cycle of poverty and make them more likely to re-enter the criminal justice system in the future. So we created the public safety assessment to try to address this injustice and this set of issues. The PSA is, as the judge just said, it's a tool. It's a tool in the judge's toolbox. And what it does is it provides reliable, evidence-based information that a judge can consider when making pretrial release and detention decisions. The way it was developed is through a rigorous analysis of about 1.5 million cases from 300 jurisdictions across the country. And what we did through that analysis was identify 9 objective factors that taken together can provide judges with 2 risk scores. One that represents the likelihood that a defendant will fail to show up for court, and another that indicates the likelihood that he or she will be rearrested. The PSA, Public Safety Assessment, also flags a small number of defendants who are at an elevated risk of committing a violent crime. The list of the 9 factors that go into the PSA is included in your press packet. One thing that's important to note in that list of factors is that they do not include information, they don't include factors that have been highlighted as being potentially discriminatory, like someone's ethnic background, the neighborhood they live in, their income, level of education, etc. And we think that by shifting to a system where decisions are based on an individual's level of risk rather than her charge, we can help to protect the defendant's rights, keep the community safe, and work to ensure that tax dollars are wisely spent. Now, as I mentioned, the PSA is just a tool in the judge's toolbox. And it does not, and I repeat this, it does not replace judicial discretion. The final ruling always rests with the judge about whether to release or detain a defendant. Currently, the PSA is being used or is in the process of being implemented in over 30 jurisdictions nationally, including 3 entire states. And I'm optimistic that its implementation here in Cleveland can help reduce unnecessary incarceration and allow judges to make more informed pretrial decisions. One of the communities that is using the PSA is in fact right here in Ohio. Lucas County, which as I'm sure you all know includes Toledo, implemented the tool a little over 1.5 years ago. An analysis of the data collected to date showed that since the county adopted the PSA, the percentage of pretrial defendants arrested while out on release had been cut in half, and significantly more pretrial defendants are being released on their own recognizance and returning to court. With respect to release on their own recognizance, in fact, that figure jumped from 14% to 28%, so it nearly doubled. As the adoption and eventual implementation process gets underway, we're hoping to see positive results here in Cleveland. And when we are deciding to partner with a particular jurisdiction, one of the most important things we look for is the level of commitment of local stakeholders to really take an honest look at their system and identify the areas where change could be most impactful. And I've done a number of these types of announcements, and never have we seen quite this level of support and diversity of support. And I think it is enormously encouraging and bodes very well for the implementation of the public safety assessment, and really indicates why we at the Foundation and myself personally are so excited to be partnering with the criminal justice leaders here on this important work. So to close, I just wanted to again thank Judge Adrian and the local leaders who have helped to make this possible. We really look forward to continuing the collaboration in the months and years ahead. Thank you.
Thank you, ma'am. I'd like to acknowledge that two additional judges, that is, have arrived. Judge Patrick Carroll from the Lakewood Municipal Court and Judge Michelle Paris from the Bedford Municipal Court. Thank you for coming. Next, I'd like for you to hear from Mayor Jackson as it relates to how he sees the PSA assisting Cleveland. Mayor.
Well, first I want to congratulate Judge Adrian on his success here. As he has mentioned, he's been at this for a long time. So congratulations, Judge. And I want to thank the Arnold Foundation for their help in helping it be a reality. When we were negotiating the consent decree and entered into that settlement agreement, one of the things that was always brought up, but is not in the consent decree, is disparity within the criminal justice system, whether it was from who got arrested, who got out on bail, who got sentenced, what their sentence was. And so one of the things that the public has always talked about beyond just the use of force was, how does the criminal justice system function, and does it function fairly? And what this does, it gives the public a sense that there is equity at least in the front end. And so again, I want to congratulate you, Judge, and thank the Arnold Foundation for helping us get to this point. Thank you.
Thank you. We're also, blessed to have the County Executive, Arnold Budish, here with us today, and so I'm going to call him forward to say a few words.
Thank you. Today is really a great day for our criminal justice system of Northeast Ohio. For us to thrive, everyone should have equal access to justice and fair treatment under the law. Now, those of you who know my wife know that she's constantly cutting out articles for me that she thinks would be of some interest, and this one was from June 28th, 2015, from the New York Times. The title is "Judges Replacing Conjecture with Formula for Bail." And the first lines, "Setting bail is a difficult task for judges. They must try to foretell whether the defendant is likely to commit another crime, hurt someone, or skip out on the next court date. Now comes help in a distinctly modern form, an algorithm." And then the article goes on to talk about the public safety assessment that was developed by the Arnold Foundation. It's a tool based on science and technology to give judges more reliable information to make their decisions. At about that same time, we in Cuyahoga County government created a criminal justice agenda highlighting bail reform, equitable charging, and early attorney assignment. The Arnold tool was a key piece for us to achieve the first two of those agenda items. This risk assessment tool will enable our municipal judges to make important bail decisions with better information. It'll also allow county and municipal prosecutors to make informed charging decisions. Now, lots of people have come together, as you correctly noted. Lots of people are here. Lots of people have come together to make this happen. I want to thank the Arnold Foundation for making the PSA available to us here in Cleveland. They don't do this all over, and we were fortunate to be one of the selected communities. I want to thank Prosecutor McGinty for really pushing and prodding this effort. Those of you who know the prosecutor knows that he pushes and prods very well, and that has helped make this happen. I want to thank Bob Triazzi, the county law director, for leading our criminal justice efforts, and there's so many others. Judge Russo is leading an important criminal justice review in Cuyahoga County that we are very involved in. And, of course, the mayor and city council president, we've been able to do a lot in a lot of different areas because we're aligned, and that's very important for the people of Cuyahoga County and the city of Cleveland. And I want to thank Public Defender Robert Tobick as well, for your efforts here. I want to thank the Plain Dealer for their extensive series on the importance of bail reform, which has helped move things along. And most important, I want to thank my friend, Judge Adrian, and all the judges of the Cleveland Municipal Court. One judge doesn't do this, although we certainly need a champion, and he's been a champion for this effort. But I want to thank all the judges for taking the lead to demonstrate how this tool can be used throughout the county, throughout courts throughout the county. So thank you, Judge Adrian.
As I pointed out to you, the person who initially had made contact with the Arnold Foundation to talk about the possibility of them coming to Cleveland was our county prosecutor, Tim McGinty, and it was through his efforts that they first stepped foot into Cuyahoga County with the idea of trying to see whether or not we were a good fit. So I'd like to ask Tim to step forward and say a few words. Tim.
Thank you. Thank you, Your Honor. I want to thank everybody for this joint effort, particularly the Cleveland Municipal Court and Judge Adrian for getting it done. The front-loading the system is an extremely important part of reform. In our old system, we really didn't know who we had well down the line. We didn't know who we had in jail. We didn't know their background. And we made decisions based simply on the charge that the police chose and aligned it, and the judges weren't in a position to formulate a good bail decision. They don't know the individual's background. They don't know the offenses he's been involved in the past, whether it be violent or nonviolent, or none at all. The bond is just set arbitrarily. If you have an overcharged case, like somebody doing the classic breaking into a garage and stealing a bike or something, if the garage is attached under Ohio law, it's a felony 1, a high bond is set. He might be 18 years old with no prior record. And by the time we really assessed the situation, we were 30 days down the line. And where have we put him? We put him in the College of Crime, the county jail. He sits there and he's corrupted by the drug dealers and habitual and perpetual criminals that are in there. It makes, and there's been many studies showing that it makes them more likely to be involved in crime later, far and above stealing a bike. What we push for and what we're succeeding in doing with the Common Police Court and the Municipal Court is assign them counsel early, eliminate the high percentage of those affected by mental health issues, drug issues, little or no record in the past, encourage diversion to drug courts that both the common pleas and municipal courts have set up, and the other various diversion programs that are out there, whether it be, and of course to eliminate the innocent and overcharged with early assignment of public defenders to them. As the county prosecutor, we want to take the people who don't belong in jail out of jail and keep the people, the equal component to us is to identify the dangerous and keep the dangerous in jail. We've had dangerous that have passed through the system, made bond, and got out only to skip bond again, harm, rape, kill other people. So we're equally concerned about identifying the right person, keep them in jail before they harm again, and we want to eliminate the low-level overcharged who don't belong in jail before they become criminalized, and which is totally unfair, but they also take up a lot of time in limited detectives that we have there's always an understaffing of detectives and an overstaffing of cases. So when you have the Arnold Foundation, and that's why I sought out the Arnold Foundation and went to New York and Philadelphia and others and look at Mecklenburg County and others that looked at it, they reduce the time spent in the jail, they identify the dangerous, they even red flag the dangerous so you can't miss him. This guy's been convicted of murder twice or whatever. This is somebody to pay attention to. He has a history of violent behavior. But those are few and far between. More often, far more often, are they overcharged and highly likely to come back. The only persons who benefit from our current bond system are the bondsmen. There's no benefit to the taxpayer, to the county financially or otherwise, or to the city. A correct identification that the Arnold Foundation proposes is proved to work in extensive testing, and we've reviewed their testing in New Jersey, New York, and the other states they've done it in. It works. It reduces the amount of time spent. We have more detective time spent on the correct cases, and it saves money. That beyond justice, of course, it's a first and foremost concern of all parties here, but it saves a lot of money, jail time, and future criminal activity that will come. So this is an award that will save our county and benefit our county in the terms of tens of millions of dollars in the long run. This costs a lot to put in cash-wise, but the long-term benefits are huge. And I appreciate the effort of everybody involved here and your leadership, Judge. Thank you so much.
Thank you, sir. Finally, I want to ask Mr. Robert Tobick, who is the county's public defender, to come forward and say a few words about what he thinks are the benefits of what we're attempting to do for his clientele.
I didn't know I was on the agenda.
I'd like to thank Judge Adrian and the Arnold Foundation for bringing this method of assessing whether a person should be kept in jail while their case is pending. It's one of the things that my office has been pushing for, is to get our clients out on bond so that if they have a job, they can do their job, or if they don't have a job, they can work with the lawyer in preparing the defense of the case. Not all people charged with the crime are guilty of that crime, and it's much easier to represent someone if they're available. This has been a very long process of getting bail bond reform, and I'm happy it's come here. And I'd like to thank Judge Adrian and the Arnold Foundation and all the people that participated. You can see this is an unprecedented amalgamation of people working for the same goal. Thank you.
Thank you. So at this point, we'd like to open the floor for questions from the press. Wow, we covered all the shots. Everybody's happy. Yeah. Okay. Thank you very much. Let me just say one thing before you leave. I'm sure that some folks are interested in next steps. And Matt, you want to kind of talk about what we can expect from the Arnold Foundation?
Sure. So the way implementation typically works is after we've managed to assess a site and make sure that they have the data, technology, processes in place, and they have a demonstrated level of support, then we start to move forward with implementation. And we have a technical assistance team who's implemented the PSA in probably a dozen jurisdictions nationally. So they have a lot of experience working with this tool, working with stakeholders. They've already been on the ground here to start planning for that implementation, which I believe will start in January or February, so early next year. And implementation usually takes about 6 months, and then we also at the foundation support an additional 6 months of quality assurance to ensure that once it's implemented, everything continues to go well, that it's being scored appropriately, and to troubleshoot any issues that arise. So it'll be a little more than a year of work together on this.
So is it like a computer program that you just type in all the information and then the assessment comes out?
So it is. It depends on what the technology system is in a given jurisdiction. It is essentially a formula that takes 9 risk factors, assigns weightings to each of them, and then generates a risk score. Usually it is partly automated in terms of the calculation and the generation of the risk scores, but usually a pretrial services officer or some other individual needs to pull the information from the criminal history record and other files. And then the calculation is done and those results are provided to the judge. And of course the judge then makes his or her own decision about what, how to take that into account and what ultimately to do with that respect to that defendant.
And so how soon, you say the implementation is January, February, but how soon can we see it actually in the courtroom level where, defendants are not being sponsored?
Typically, it's about 6 months from the time implementation starts until it goes live. I mean, obviously there's some variation there. It can be a little faster, it can be a little slower, but usually 6 months is what it takes. And a lot of that Part of that time is taken with training and education and some policy making with the stakeholders around what recommendations to make for each combination of risk scores. But then there's also the not very glamorous behind the scenes work around data and programming and just making sure that they can pull the information in the time needed to score the assessment. So that's usually what takes about 6 months before it goes live.
Okay. Well, thank you very much for coming, and we are excited as we move forward, and we will keep you posted as to how we're doing.